You can put us on, Shannon.
All right.
Hello, Your Honor.
Good afternoon.
Afternoon, Your Honor.
Okay, looks like everybody is present now in the matter of Minuteman versus Gorson.
Who's the other guy?
Mr. Gorson, the defendant, is
Oh, that's
present,
him. Okay. And Bruce.
and Mr. Inocencio on behalf of the plaintiff. Were either of you expecting anyone else to participate today?
No, sir.
No, Your Honor.
Okay, Mr. Inocencio, I think
I can give the court a
we're
brief
here
summary.
for entry of an order, or no, I'm sorry, objections
Correct,
to a proposed order.
correct. And-
Okay,
And Mr. Gorson has set forth his objections in the proposed objections. I would note for purposes of the record, Your Honor, that in light of Mr. Gorson's situation and his efforts to eventually dissolve the LLC, I note that although he does not have counsel here on behalf of the LLC, that this court might take some leeway with him, even though he is technically required to have counsel representing the LLC. So just for the record, I do want to make certain that the court is aware that we are not taking issue with the fact that that Triton Sewer and Drain Services LLC is not represented by counsel here, and that Mr. Gorson is representing himself and appears to be taking efforts to dissolve that entity.
okay,
Okay. As far as Mr. Gorson's objections, I went through them today, and what it appears to me to be here is two key issues. And one is that the date for the completion of the non-competition is wrong, according to Mr. Gorson. Mr. Gorson's position was that this court continued the non-compete agreement through 2023 because the last day of his work was in May of 2018. I included the date in 2024, thinking that it was based on this court's prior ruling relative to our motion for summary disposition. The second issue that's raised in the objections relate to it's not exactly an issue that, well, I shouldn't say it's not exactly. This is not an issue that was addressed at the hearing on the motion for summary disposition, but there appears to be a claim that the plaintiff should not be entitled to pursue damages in light of the defendant's efforts to proceed with a cease and desist and agreement to never further violate a non-competition agreement. Your Honor, in light of that, and in light of discussions I've had with my client, I can assure this court that we would be willing to today proceed with entry of an order that allows Mr. Gorson the relief he has requested in his objections, which would be to extend the non-compete agreement to 2023. And we would agree not to pursue any damages against Mr. Gorson after entry of that order, which I would expect to have to the court under the 7-day rule within a day or two. And this matter could be behind everybody.
Mr. Gorson, is that something that would be acceptable to you?
Okay, yes, sir. In light of what Bruce Inocencio is discussing about getting the company dissolved, I can represent under my, I guess, knowledge. I'm, not an attorney by any means, but I do have my paperwork from the IRS, which shows that the company is dissolved. Which excuse me.
I take you at your word, even though I have not seen those documents.
Okay, it's here. So
Okay.
if
I
you would
believe
like a copy, I'll be happy to present that to you.
Okay.
However, the discovery phase was over, so I did not submit them to you because I did not
Okay.
know that. So
I understand.
with that, I also would like to, so you had also mentioned the Okay, so the date that you had put on this 5-year agreement you want me to settle is actually, the date was wrong. And I would also, I think you were, I don't know, eight months wrong or something to that effect. You were extending time onto that. So I also wanted to bring to light that. And it's been a continual and repeated thing dealing with you guys for 2 years. I followed your cease and desist order. Oh, well, just shy of 2 years, excuse me. I followed your cease and desist order to the T, shut everything down. In fact, I didn't even know the company needed to be dissolved until I did a 6.5-hour interrogatory deposition with you for a company that never even opened. I mean, and to be honest with you, if you looked at the exhibits I sent you, Bruce, which you have them, because you filed a motion to get all of my exhibits dismissed, you will see in all of that paperwork everything that you needed. I mean, your client thought that I used the gift, which I sent you a picture of the gift, for this company. I did not. I actually have a notarized contract that I took out based on what your client told me. And it's fine if you want to disagree. I completely understand.
We're just not here for that, Your Honor.
Excuse me.
We're not here for any of those issues. This
So,
puts
Mr.
it behind.
Gorson, let me see if I can cut through this. I realize you have frustration with all that has happened in this case. I want to make sure you understand that I believe what Mr. Inocencio is offering today, once we agree on what the end date of this non-compete agreement is, that once that order gets entered, there won't be any further attempt to extract damages or attorney fees from you. That will be the end of the matter. It'll be put to rest. My question to you, assuming we can find the right date, is that something that you find acceptable?
No, sir.
What do you want to have happen?
Well, if I could actually bring up some things that I've come across as far as the non-compete, the whiteout on there.
Your Honor, I'm going to object.
Hold on a minute. Hold on. So before you tell me all the whys,
Yes, sir.
all the reasons for whatever it is you're going to ask for, assuming I listen to all those reasons, what would you ask me to do as a result of all those things?
Well, Your Honor, to be honest with you, after the amount of time that's passed, and I think under the situation, I would like to be let go of this non-compete for a few reasons. One of the reasons is
Okay, fair enough. We don't need to go into the reasons why. So
Yes, sir.
you oppose the court entering any kind of order that continues to prohibit you from engaging in competition with Minuteman.
Yes, sir. In fact, I've been asking them to do this since the beginning, and Bruce called me 10 minutes before court asking me to accept on this, which the date was wrong, and it's just been a continual game. I just want to be done with this, and I want to move on. I took a loan out based on what Mr. Konopacki had told me. I even have text messages from him kind of elaborating, to the reasons why he actually did this to me. I mean, I just want to be let go. I mean, I've been out of there over 2 years.
Your Honor.
When you say let go, you mean let go from any further exposure in this case and let go from any prohibition on your ability to do drain cleaning services?
Yes, sir.
Okay,
Your Honor, may I respond briefly?
sure.
So the call that I made to Mr. Gorson about 10 minutes ago or 15 minutes ago, or actually now about 25 minutes ago, was essentially offering what I am offering now in an effort to save this court the time associated with this hearing. I wasn't trying to give Mr. Gorson any impression that we were going to be doing anything else other than what I'm suggesting now. And I'm following right in line with the relief that Mr. Gorson requested in his objections, saying that he believed that the 5-year period should have started May 29, 2018, plus 3 weeks after his last day of employment. If the court looks at his objections, it says June 19, 2023. That's what I was proposing to him this afternoon on the phone. That's what I'm proposing now, that we would go with that date and that there would be no further claim for damages. Mr. Gorson had 5 months to respond to our motion for summary disposition and did not. This court heard oral argument on that motion. He acknowledged having violated it, and here we are. All I want to do is put this behind us. We will not pursue damages, and we will use the date that he suggested. I don't see how that's any different than what he
All
wanted.
right. Well, when I got this, when I looked at this file last week, whatever day it was I looked at it, probably Friday, I went back and I listened to and watched the arguments on the day that your summary disposition motion was heard. And in fact, what came across very clearly was that at least at that time, Mr. Gorson wasn't contesting the non-compete agreement and was willing to abide by it. So I never got into the merits of the case. It sounded like he wasn't going to oppose it, was going to abide by it. So at that point, it sounded to me like he wasn't opposing the motion. And I proposed a mechanism that would accomplish that. I didn't really rule on the merits. I never got into the merits. I never got a chance to evaluate the merits of the motion. It sounds like today he is opposed to the motion itself. He's made at least one comment indicating before he ever did anything, he asked for a copy of the non-compete, was told there wasn't one, and only after he borrowed a bunch of money and engaged in this business that he gets notice that there is indeed a non-compete agreement. The other thing that I frankly have concerns about is whether there is a legitimate business interest that's protectable under the Michigan Antitrust Reform Act. An agreement in restraint of trade, if not specifically exempted by the Michigan Antitrust Reform Act, is unenforceable. It's in violation of free trade. And I acknowledge I don't have a full understanding of what exactly it was Mr. Gorson did for the plaintiff, but my very basic understanding is he cleaned sewer drains. I have difficulty understanding what reasonably protectable business interest in the cleaning of sewer drains requires a non-compete agreement. It seems like pretty basic stuff. Now, if he were going after customers, clearly that's protectable. But I don't get the sense that he's done that. If it's, what
Your Honor, if I could-
specialized
I can address that.
information exists about cleaning sewer drains? I think you could watch a YouTube video and figure it out.
Well, Your Honor, you've mentioned that a couple of times at different hearings we've had and settlement conferences we've had since the court ruled on the motion before, but that's not accurate. This is a situation, this isn't a job that just anyone can start doing without training. And Mr. Gorzen admitted that he had access to Minuteman's confidential information, including customer names and pricing information. That happened on multiple pages of his deposition transcript. He testified that he received extensive training from Minuteman in providing sewer and drain cleaning, which required a monetary investment on the part of Minuteman to make that happen. That testimony regarding that training can be found on pages 46 through 50 of his deposition transcript. And then he utilized that training and technical know-how provided to him by Minuteman to open his own sewer and drain cleaning business. And Your Honor, when I asked him about the operational standpoint of or status of his company, he admitted under oath that the defendants could start competing with Minuteman again at any time. This is when he claimed that the company had been closed. And his quote on page 171 of his deposition was, we could do anything we wanted tomorrow, unquote. So I don't want to belabor this over and over again, Your Honor, but he was trained by Minuteman at Minuteman's expense. He had access to all of the confidential information of the customers of Minuteman. Your Honor, if Mr. Gorzen wanted an opportunity to address this specific issue, he had over 4 months to respond to the motion for summary disposition, and his objections to this court's ruling really should only be based on form, according to the court rule and the existing case law that addresses this issue. Now, if he didn't like the outcome, obviously he could have filed for a motion for reconsideration or a rehearing. He didn't do that. This court has the authority to rule upon the objections to indicate whether or not those objections are actually have merit relative to the court's ruling. And if the court looks at, there's a case from 1992, Riley versus 36th District Court Judge. I mean, parties have an opportunity to move for rehearing or reconsideration under MCR 2.119F. This is tantamount to that motion. When a court makes its ruling, the only objections that can be filed relate to form. And this is actually asking for a rehearing on the merits. There's been no testimony presented to the court to suggest that the merits should be addressed at this time. I don't understand what it is about the order that we presented to the court that does not accurately reflect the ruling. Now, if the case is that he doesn't like the ruling, he has relief. He could go for the motion for rehearing or reconsideration. The order hasn't entered yet. The clock hasn't started running on that. But to say that anytime someone doesn't like the outcome of a hearing, that they can then file objections to the proposed order, that will turn the Michigan court rules on their ear. That's not the appropriate mechanism, and the order should have been entered because the objections do not speak to the ruling. I don't even believe, frankly, that the objection has merit relative to the date. I think that the date I included was an accurate representation of what this court ordered. My offer today was just to say, my client's willing to put this all behind him. Let's enter the order that says that the non-compete continues on until the 5-year period that he referenced in his objections, and we will agree not to pursue damages like he also included in his objections. Neither one of those should have been included in the objections because they don't relate to specifically what this court ruled upon. This court can't go back and change its prior ruling based on objections to an order. The order still has to enter that reflects the outcome that the court ruled from the bench that day. And if Mr. Gorzen doesn't like it, he can then file the motion for rehearing. I'm hoping to avoid all of that put it behind us, not pursue damages. Let's go with the date he's proposed and let's end it. Otherwise,
All right, thank you. Thank you,
Thank you.
Mr. Inocencio.
Thank you, Hunter.
I stand by what I said earlier. At the original hearing, I did not rule on the merits of the case. I simply implemented what sounded like the consent of Mr. Gorzen that he was not going to contest the non-compete agreement and was not going to move forward. I never addressed the merits. I have serious questions about the merits. Not only what I've already said, but also the length of the non-compete agreement. 5 years for sewer cleaning?
Thank
It's
you.
just way, way, way beyond the pale. I've seen 5-year non-compete agreements with highly technical, specific, valuable, confidential trade secret information of a highly technical nature. I've never seen it for prices and customer lists. And you can tell me he received this highly technical training without very specific proof as to what that is. I find that extremely skeptical. I'm not going to enter this order. I will schedule this matter for a trial at the earliest possible date, and we'll address the merits of whether or not this indeed is an enforceable non-compete agreement. And if it is, what would be a reasonable period of competition that would apply to it? I am not going to be a part of entering an order essentially enforcing an agreement that I have serious doubts as to its legality under the Michigan Antitrust Reform Act.
Your Honor, may I ask
So I'm not going to enter this order. We'll find you a trial date.
may I ask one question?
Sure.
Thank you. In light of the fact that the matter is going to proceed past today, is it safe to assume that Mr. Gorzen will be required to engage counsel to represent the entity? I'm not sure how to deal with that at this point, because obviously Michigan law requires that.
The entity's been dissolved according to what Mr. Gorzen has said. Mr. Gorzen, Mr. Inocencio makes a valid point. A corporation, a limited liability company you cannot represent that entity in court. Only an attorney can do that. But
Yes, sir.
if the entity is dissolved, it's a moot point. Mr. Gorzen can enter into drain cleaning business without this LLC as a DBA if he chooses, or he could form another entity at some point in the future.
So
If this entity is dissolved, then he can't represent it. Whether it was still an active LLC or is now a dissolved LLC,
Right.
He cannot represent it.
So Mr. Gorzen needs to have counsel represent that entity at the trial, because that
Well,
entity is still,
If that entity chooses to defend itself, it will need counsel to do that.
okay.
I'm not going to compel Mr. Gorzen to hire an attorney to represent a dissolved LLC. But I am going to tell him today that he can't represent that LLC.
Okay, thank you. I appreciate the clarification, Your Honor.
Okay, that concludes our hearing. Thank you, gentlemen.
Thanks, have a good day.